CJC 377.
Chair, before we continue, may I just come and say, give some input? I think since yesterday, there were three things that I said I will be guided by you, Chair, on aspects, as we discussed, on confidentiality and the docket, which is currently before court. So what I want to bring to Chair's attention, the A1 state...
Sorry, I made a serious mistake. Good afternoon, Mr. Bodlani. And apologies for not recognizing you or greeting you.
Good afternoon, Chair. Good afternoon, Commissioners, and apology accepted. It doesn't happen every day that the apology comes from that side of the table. But we take it. Thank you.
Thank you.
Thank you, Chair. Can I proceed?
Yes, please, Colonel.
Thank you, Chair. I think after yesterday's proceeding, Chair, and as the investigating officer in the matter of let us call it the Mukwele docket that is before court, the A1 statement forms part of the docket which is before court. But I tend not to turn on and look at the media and everything that's going in my preparation. But the A1 statement is all over social media and on that aspect. One thing about the affidavit, it contains the name of the complainants, and I have my concerns that that particular A1 statement is an exhibit, and it's a statement that's going to be presented in court. And I'm a bit concerned, and that's why I want to bring it to Chair's attention that I'm not too sure whether there are further documents in this case file that is also going to be flighted out there in the public domain when the case currently is before court. That's just my concern this year. And therefore, yesterday, I said I'm here to assist the Commission to seek the truth, but at the same time, I have to be cautious that the matter is before a presiding officer in court, and these witnesses and myself will have to testify. These are my concerns. Thank you, Chair.
Thank you, Colonel.
Thank you, Chair. I hear the witnesses' concerns. My concern is, I'm not clarified as to exactly what the witness is raising, because IDEX counsel is present. And what I think I deduce from what he says is that we should not dig into this particular docket because it's before court. We are back to that sub judice issue. This particular docket is not the one that I indicated we had agreed will be treated with caution, because that particular docket is still under investigation.
Which is docket number 3, as I understood yesterday.
Yes, and
there's 1, 2, no problem, and then number 3.
In fact, it's number 4.
Oh.
It's number 4. There are 4 of them. 1 and 2 are unrelated dockets. This particular one we are dealing with, and docket 4, concern about the same facts, or arise from the same facts. And I think it's common cause that they concern General Khumalo. So docket 4, the witness touched on it very briefly yesterday, and that is the docket that carries this particular caution that because that one is still under investigation, we should tread carefully. This current docket is the one, the charges for which General Khumalo and other members of the panel were arrested, have appeared in court, are on bail, and we confirmed that there are no further investigations in that matter. The docket in its entirety has been fully disclosed to the accused to prepare for the criminal trial. It was on that basis that it was decided that they will not pursue the confidentiality rights insofar as this particular docket is concerned. So if that is where we landed yesterday, that we will not apply confidentiality to this. How I understand the witness is raising a sub judice point, precisely the point that IDEC yesterday said it was no longer pursuing. That's why I say how to deal with it, perhaps I would require to get a better understanding, because now I'm in a space where the witness is reviving an application that has been disposed of on the basis, as we mentioned to the chair yesterday, and he placed on record. So is he reasserting the sub judice rule to this docket? If not, is he invoking the right to confidentiality to this particular docket, in which event then we would have to have a full-blown argument as to why confidentiality attaches to this document. But at the same time, it is unfair for me to have that debate with a witness, because it's a legal debate in circumstances where he's represented. So maybe Mr. Botlani would like to come in and explain where we land. Do we reopen that application for argument, or what do we do? Thank you.
Chair.
Thank you, Ms. Zillo. Colonel, I was going to invite Mr. Botlani to be the person who addresses us on this issue. I do not know whether before raising the issue you had alerted him to the fact that you were going to be raising the issue. I do not know. Perhaps let me hear from Mr. Botlani.
Thank you, Chair.
Yes.
I don't understand the concern raised by the witness to be an invitation to the opening of a debate that we've had with our colleague and have closed it in the manner that we have. Indeed, I gave counsel before these proceedings resumed this afternoon. The concern, as I understand it, is the documents being made public. I think it's the flighting of the documents, not that questions on the document cannot be asked. That's not what was referred to me by the witness. So him being asked questions on the documents, it's something that he accepts has got to happen, because otherwise would be hindering this commission from doing the very duties that it has to discharge. But his concern was, as indicated to me, the documents now being available out there in circumstances where some people are still going to deal with them in court. That's what was relayed to me. Not that our colleagues should not ask him questions about the documents.
All right. If some of the question, because I heard the Colonel even refer to names of people, there is names that may be appearing on the documents. How should the documents be treated? Should there be a need to refer to the names in a context where it's quite clear that that's based on the content of the documents? How are we supposed to deal with it?
It's a difficulty. I've tried to consider it with my colleague, Mr. Ramatsek-Sanemi, but we couldn't come up with a mechanism. Because indeed, one cannot say this is a linear process where one can put a blanket statement and say there shall not be reference to names. There are going to be circumstances where the context suggests that reference must be made to a particular name. For instance, if one speaks about the A1 statement, for instance, somebody deposed to it, it's there. And one is not going to be able to speak about the A1 document without speaking about the person who deposed to it.
And sometimes even the point being made may only make sense if specific reference is made to the person.
Indeed.
Yeah.
The A1 statement being, for instance, a case in point. I'm in the hands of the commissioners, really. There is no mechanism that we could come up with as to how do you deal with circumstances such as this, especially, for instance, the docket that we're dealing with. We know that it has been discovered. It is out there. The accused have had access to it.
If I may ask, what is this the same one? Is this the same one we dealt with yesterday?
Confirm, Chair, it is.
Oh. Yeah. What Mr. Law has done is to refer to page 61 thus far. Or 681, I'm sorry.
681, correct.
Yes.
Yes.
And we've been dealing with this document backwards and forwards. So I don't quite understand how the issue arises all of a sudden today. That is the kernel's concern. I know it's not your concern, the kernel's concern. We dealt with this document backwards and forwards yesterday, and we referred to there was it in this one? Yes, there is reference to names here, but of course, in paragraph 3, that's reference to the people that were being investigated. But with regard to just this one document, I do not quite get it what the issue would be or what the concern would be.
I follow you, Chair, because insofar as the document that appears at page 681, to the extent that we went in and out of it yesterday and mentioned names, there's no undoing that.
Yes.
There's no taking back, for instance, reference to a Mr. Adams, because it was done.
Yes.
So I do understand what you're putting to me, that
Yeah.
how does it arise, because this is not a new document.
Yes.
I again understood that concern, perhaps, even though I'm not able to proffer to you a solution to the concern, to be referring to not necessarily this document, but further document. But your concern is where context dictates that reference must be made to a particular name. How does the Commission deal with it? I'm not able to provide assistance, unfortunately, to you. But insofar as the document before you now, if for the lack of a better word, damage has been done, there's no undoing it now.
Thank you, Mr. Padayachee. I don't know if you want to respond. But
Yes,
my
Chair.
inclination is to rule that we continue as we did yesterday. We are not talking about any other document. It's a document that we engaged with at length. You, my co-commissioners, and me. We dealt with the document at length. So I just do not follow what the concern should suddenly be.
I would agree, Chair, on the basis that the Chair posits that the horse technically has bolted on this particular document. But I have a bigger concern. There are a lot of documents in that particular docket I want to deal with, and that is the question that I need addressed. Is the sub judice rule going to apply to them? Is confidentiality being asserted over those documents? And if so, I need to know how they are intended to be treated.
Perhaps let me ask this question of Mr. Padayachee. Mr. Padayachee, it is so, as Ms. Silo says, that this particular docket does not fall, or is not the one about which we were told yesterday there must be caution in dealing with it. This document falls under the first category, which is those dockets will be dealt with as the evidence leader pleases, as it were. I'm putting it very loosely. No issue, no concern about that category of dockets.
And I stand by the representations that were made here on day one. As to
So no issue about this specific docket. It falls under the category in respect of which you said no issue there.
Maybe I should start here. The difficulty we have is we represent an institution that has lawyers in it, and there's obviously going to be varying views here and there, regardless of the counsel that one gives. But insofar as what we presented here on day one as to the treatment of the documents, we stand by that. The documents, in our view, that are affected by the sub judice rule are as identified by the evidence leader. That remains the position. We stand by that.
But you agree that this one is because there was a separation of the documents. There was one document in respect of which we were told caution must be exercised.
Indeed.
Docket, I think I said documents, docket, and that was just one. And the rest, there was no issue there. I called upon you to confirm, and you did.
Indeed.
So
And I stand by that confirmation.
yeah, that's how we should deal with it. If this falls under the category in respect of which there is no issue, let's deal with it on that basis. And it should not matter whether IDEC has lawyers, as Mr. Bodlani said. That shouldn't matter. Thing is, when Mr. Bodlani came, we assumed that he had instructions. And based on those instructions, he adopted the position that he did on the first day of the hearing. And we should proceed.
On that basis?
Yes, along those lines.
For avoidance of doubt, Chair, and just to be clear, we are proceeding with the docket on the basis as we concluded yesterday morning.
Yes.
So no confidentiality attaches. There are no restrictions to what I can extract publicly from that docket. That is very key.
Yes.
Because our hearings are public. If anything that is ventilated in this room must be done so publicly. That includes flighting the documents. That's part of the public hearings. Unless confidentiality is asserted in terms of Rule 10.4. So we can't be between seats. And as I understand Mr. Bodlani, I think I agree with him that we had a decision yesterday. There are no restrictions absolutely on this docket, except the usual Poppy Act. Yes. Otherwise, we deal with it as it's necessary. That's how I structured how I'm dealing with the testimony of this witness. The witness seems to want to backpedal that and assert some level of confidentiality without necessarily invoking Rule 10.4 in its entirety. So if that's where we land, and IDEC's counsel and I are clarified as to the position regarding this particular docket, then perhaps I'll call upon the chair to explain to the witness.
I think based on what Mr. Bodlani said, the issue is resolved. I will just say, purely as a matter of courtesy to the Colonel, you have legal representation. If you have issues or concerns, you should raise them with your legal representatives before we come in, so that submissions are made by your legal representatives. We cannot have a situation where you address us on legal issues when your legal representatives are here. So from where I'm sitting, the issue is resolved, and this is not and I would assume that you were part of the agreement, or you or IDEC gave instructions in that regard. So from where I'm sitting, the ruling is that we proceed.
Chair, may I respond?
All right, let me...
Thank you, Chair. Let me set the record straight first, Chair.
Yes.
We are here for a purpose, and that is to assist the Commission.
Yes.
And to get down to the truth of what is there.
Yes.
My concerns have been relayed to Council. They are aware. My concerns was also during the consultation process given to the evidence leader. And that was that the matter, the docket, is currently before court. So, but what I want to say, I do not want to come across like we want to hide anything. So when we started the process yesterday, there was no problem. And I said, Chair, if you will remember, I will be guided by you, because as the Chair, you would know where the docket, entry into the docket has been, we will probably have prejudice in it. My concern is that the A1 statement was flagged and it was posted all over social media. So we've dealt with the A1 yesterday and the questions that were asked there, which I responded to uncomfortably. But the main thing is, what other documents are going to be
how these documents get onto that platform has everything to do with the fact that they are being flighted. And they are being flighted because no confidentiality attaches to them. That was our understanding. That was what was said at the beginning of the proceedings yesterday. And they were dealt with fully in open session yesterday. So I would not understand why there should suddenly be an issue just because they happen to be out there on that platform, that is social media. We have no control over that. Once they are public, they are flighted here, people can grab them and do with them whatever they will.
Yes,
So
Chair.
it's you either claim confidentiality and say the documents should not be flighted, which has not been done here. There's been agreement that they can be, or rather, they can be flighted publicly. They can be dealt with publicly. So, or you could have said, no, they should not be. I'm claiming confidentiality for ABCD reasons, and then the commission would decide whether or not it agrees with what you say. That is not what happened. So I cannot understand why at this late hour you should be raising the issue that you are raising, just because you happen to see the documents on social media. It cannot be.
I understand, Chair.
Yes.
But what I'm saying is that...
Can we please move on? You have your, if you want us to adjourn, and I can give you 5 minutes for you to adjourn, we cannot be addressed by your legal representatives and by you on a legal question. We should have been resolved between you and your legal representatives.
May I request that...
You give instructions to your legal representatives. We can't have you, Mr. Bojani has said there's no issue with this. You are suggesting that there is an issue. What do? Do we reach a decision between contradictory positions placed before us by you on the one hand and by your legal representatives on the other hand? That's the most awkward situation I've ever seen. If you want us, we can go out for 5 minutes and come back once we've been told to come back.
Could I request that adjournment for 5 minutes, please?
Yes. We'll come back when we are told to. Let's